American second-class citizenship. Immigration and naturalization law was only part of what made the United States a late 19th century leader. Alongside it came American citizenship law. Over the same decades of the late 19th century, the United States was developing some distinctive forms of second-class citizenship. Mark Mazauer summarizes some of these forms and speculates that the American law of second-class citizenship would have been of interest to Nazi lawyers as they set out to create their own form of second-class citizenship for Jews at Nuremberg. Inside the USA, whose racial laws and eugenics movement had earned Hitler's praise in the 1920s, Native Americans were viewed up to 1924 as nationals, but not citizens, a distinction that late 19th century American commentators acknowledged to be the prerogative of a great colonial power. Puerto Ricans were defined constitutionally much as the Germans later did the Czechs. They were foreign to the United States in a domestic sense. Mazauer is right. He is right, as we shall find out shortly, that Hitler, following in the footsteps of Theodor Fritsch, admired American race law. And he is right that the treatment of Native Americans and Puerto Ricans, both carefully discussed in the German legal literature, offered models of second-class citizenship that intrigued Nazi policymakers. But the full story also includes two other especially important populations, Filipinos and especially American blacks. Especially American blacks. The problem of black citizenship is a very old one in America, with a history too long and complex to be rehearsed here. What matters most for my purposes, and what mattered most to Nazi observers, were the developments in the creation of second-class forms of black citizenship that dated, once again, to the later decades of the 19th century. During the antebellum period, blacks were denied citizenship status in one of the most reviled decisions in American constitutional history, Dred Scott v. Sandford, which was instrumental in triggering the Civil War. After the victory of the North, Dred Scott was overturned as black citizenship status was, in principle, guaranteed by the 14th and 15th Amendments. But with the collapse of Reconstruction, blacks especially, but not exclusively Southern ones, were deprived of meaningful political rights by a host of late 19th century legal subterfuges designed to evade the strictures of the post-Civil War Constitution. The right to vote in particular was denied to virtually all Southern blacks. The techniques involved included, notably, literacy tests, a device that had first been used by Connecticut and Massachusetts in the 1850s as a means of introducing covert racial restrictions in immigration. Literacy tests were a clever and influential American legal invention imitated by the Australians in their own racially restrictive immigration legislation of 1901 and recommended by the influential James Bryce for the Anglophone world more broadly. Alongside literacy tests came grandfather clauses, limiting voting rights to those whose ancestors had voted before emancipation, poll taxes, and more, including the creation of a system of political primaries that guaranteed exclusive rule to the Southern Democratic Party. The Supreme Court did not hesitate to validate such stratagems despite the guarantees of the Reconstruction Amendments. The net result was that American blacks, while de jure citizens, were de facto second class. Here again, Europeans, and Germans in particular, took note. In fact, the black second-class citizenship in America was a source of real fascination for leading German intellectuals in the decades before the Nazis' rise to power. Max Weber was one of them. Within American democracy, wrote Weber in a 1906 newspaper essay, using an excitable exclamation point, equal voting rights were rights for non-coloreds, since for Negroes and all racial mongrels, Mischlinge, they de facto do not exist. Weber believed this was a typical product of the Protestant ethic in America. Weber was by no means the only major figure to take an interest in this aspect of American racism. Edward Meyer, the immensely erudite ancient historian, published a book about America that explained the relevant practices in careful detail. All means are used to render the Negro's right to vote illusory, he wrote, surveying the wealth of legal devices invented by Americans. The English-speaking Americans, observed the eminent sociologist Robert Michels, deny the Negro any form of equal rights. He, too, worked through the legal details. Early 20th century German authors regularly observed that the political rights of American blacks were, as standard texts reported, a dead letter. Despite the guarantees of the Reconstruction amendments, those political rights had been withdrawn. Without ever saying so openly, the Southern states had made black voting rights a nullity. De facto black disenfranchisement may have been the most striking and noticeable aspect of race-based second-class citizenship law in turn-of-the-century America, but it was not the only one. Also of considerable importance in the making of American second-class citizenship was the now widely forgotten case of the Puerto Ricans and Filipinos. Victory in the Spanish-American War in 1898 brought the United States colonial possessions in Puerto Rico and the Philippines. The consequence was a minor crisis in American constitutional law. America had never sought the sort of overseas imperial power that the European countries had been accumulating, and the 14th Amendment seemed to leave little room for the creation of a class of colonial subjects. When America acquired new territories, the inhabitants were supposed to become citizens. Nevertheless, there was widespread sentiment against granting the inhabitants of the new territories full citizenship. The Philippines in particular, which became the site of a nasty American war, was home to a Pacific population that Americans regarded as belonging to an inferior, or at least for the moment, hopelessly backward race. In a series of decisions known as the Insular Cases, the Supreme Court consented to the creation of a de jure form of second-class citizenship for the newly conquered populations. The Constitution, held the court, permitted these colonial subjects to be treated as mere non-citizen nationals. The Insular Cases are little remembered by ordinary Americans today, but they were a subject of intense interest at the end of the 19th century and beginning of the 20th, and contemporary legal scholars highlight them as a key development in American race law and the making of an American empire. Europeans, too, paid attention. The struggles of democratic America with the creation of subject status for colonized peoples were a matter of international interest in the age of European imperialism. In particular, early 20th century Germans, including some very prominent scholars, created a substantial literature on American colonial law in the decades before the Nazis came to power. Perhaps the most striking of these German students of American second-class citizenship law was Erich Kaufmann, one of the most eminent and controversial German Jewish lawyers of the 20th century. Kaufmann, a brilliant professor of public and international law, was a man who felt the pull of the German far-right wing in the 1920s. He associated with proto-fascists in Weimar, and after the Nazis took power, he hung on in Nazi Germany until 1938. Surviving the war in hiding, he returned after 1945 to take up a prominent professorship, despite the fact that the American authorities described him as unsuited for the indoctrination of German youth with the values of democracy. This figure from the eerie world of the interwar right wing, one of a number of leading Jewish intellectuals whose political sympathies could draw them precariously close to the orbit of fascism, made the American colonial experience the subject of his first book in 1908. Kaufmann's book described at great and admiring length how America, having been called to the historic task of a colonial expansion of its possessions and its sovereignty, had confronted the question of whether an uncivilized population can be governed according to the norms guaranteed by the Constitution to superior, hochstehenden citizens. Kaufmann devoted attentive energy to describing the work of the Supreme Court in the Insular Cases and registered his deep respect for the subtlety of American judges and the wealth of life and immediacy to be found in the American common law. The early 20th century witnessed the rise of a cult of a kind of common law worship in Germany, and Kaufmann clearly participated in it. At first glance, the picture that the Insular Cases offers to us is exceedingly motley and almost confusing, especially to an eye that is accustomed to German decisional law. As we study it more deeply and reflect on it in an unbiased way, however, we must concede that there is a wealth of life and immediacy in these decisions. A thorough intellectual and juristic examination of the material from the most varied points of view, a penetrating recourse to the ultimate questions, an impartial formulation of the arguments for and against, and a proud appeal to the living legal intuitions of the American people that lie behind them, which reveals the high legal and political talents and the cultivation of the people of the Union. As we shall find out, Nazi jurists, too, would see much to admire in the life and immediacy of American common law racism and the living legal intuitions of the American people on which it was founded. Kaufmann was not the only prominent commentator on the American colonial experience and its legal consequences. Two famous scholars, the German Hugo Münsterberg at Harvard and the Germanophile Ernst Freund at the University of Chicago, published books in German recounting the American adventures in colonial conquest and law. Freund, in particular, explained how the United States had created a new category of subjects without citizenship rights. In so doing, he explained, America had invented a novel form of law closely analogous to early 19th century state statutes barring free blacks and the late 19th century statutes barring the Chinese. America was pioneering a range of forms of race-based second-class citizenship. There was other commentary as well. As a leading German journal reported a couple of years before World War I, in language that anticipated the Nuremberg Laws, Puerto Ricans and Filipinos had been subjected to the status of Schutzbürger zweiter Klasse, second-class citizens entitled to the protection of the state, but not to full political rights. America, in the eyes of this German literature, was a laboratory for experimentation in diminished citizenship rights. The Nazis pick up the thread. Thus, the Nazi movement emerged in a Europe familiar with American immigration and second-class citizenship law, and sometimes fascinated by it. And the familiarity and sometime fascination accompanied the early development of Nazism as well, and continued into the years of the making of the citizenship law proclaimed at Nuremberg. In tracking the Nazi strain in the European engagement with American race law, the place to begin is with the movement's Bible, Hitler's Mein Kampf. The second volume of Mein Kampf, published in 1927, laid out Hitler's vision for German renewal. That vision drew broadly on the Nazi Party program of 1920, 5 of whose 25 points involved citizenship. The 1920 Party program called for sharp limits on citizenship, which was to be restricted to persons of German blood, along with a scheme of disabilities for resident foreigners who were to be threatened with expulsion. 4. Only a Volkskammerad, Volksgenosse, can be a citizen, Staatsbürger. Only a person of German blood, without regard to religion, can be a Volkskammerad. Accordingly, no Jew can be a Volkskammerad. 5. Any person who is not a citizen should be able to live in Germany merely as a guest and must be subject to legislation for foreigners. 6. Only a citizen is permitted the right to decide on the leadership, Führung, and laws of the state. Therefore, we demand that every public office, regardless of what kind, regardless of whether it is an office of the Reich, of the constituent states of the Reich, or any municipality, be accessible only to citizens. 7. We demand that the state obligate itself to provide the opportunities and wherewithal of life in the first instance strictly for citizens. If it is not possible to provide sustenance for the entire population, then nationals of foreign countries, non-citizens, must be expelled from the Reich. 8. All further immigration of non-Germans is to be prevented. We demand that all non-Germans who have immigrated into Germany since August 2, 1914, be immediately compelled to leave the Reich. These demands, which anticipate so much of the far-right agitation that is troubling Europe again today, established the propositions that would be fundamental to Nazi citizenship law as it emerged at Nuremberg in 1935. In Volume 2 of Mein Kampf, Hitler built on the 1920 Party program, developing a more elaborate conception of race-based citizenship. But as he turned to the citizenship problem in 1927, Hitler was able to seize on a source of authority that had not been available in 1920, in the form of the new American immigration statutes of 1921 and 1924. The Nazi leader certainly saw things to dislike about the United States in this period, hating Woodrow Wilson, the architect of the Peace of Versailles, and detecting the lurking influence of Jews in much of American society. But it is a striking fact that praise for American race policies and envy of American power predominated in his pronouncements in the late 1920s, particularly when it came to American immigration legislation. Hitler, too, like so many Europeans before him, regarded the United States as the obvious leader in developing explicitly racist policies of nationality and immigration. His treatment of citizenship in Mein Kampf began with a characteristically sarcastic account of the state of German law. Today, the right of citizenship is acquired primarily through birth inside the borders of the state. Race or membership in the folk play no role whatsoever. A Negro who previously lived in the German protectorates and now resides in Germany can thus beget a German citizen. By the same token, any Jewish child or Polish child or African child or Asian child can become a German citizen without further ado. Apart from naturalization through birth, there is also the possibility of subsequent naturalization. Racial considerations play no role in this whatsoever. The entire process of the acquisition of citizenship is hardly different from joining an automobile club. After demanding the acquisition of citizenship take a more meaningful and elevated race-based form, Hitler then turned to the only example on the international scene of a praiseworthy order. There is currently one state in which one can observe at least weak beginnings of a better conception. This is, of course, not our exemplary German Republic, but the American Union, in which an effort is being made to consider the dictates of reason to at least some extent. The American Union categorically refuses the immigration of physically unhealthy elements and simply excludes the immigration of certain races. In these respects, America already pays obeisance, at least in tentative first steps, to the characteristic Völkish conception of the state. American legal scholars have written a great deal about the racism of the 1920s immigration statutes, but they seem not to have taken notice of the startling fact that those statutes were lauded by Hitler himself as the prime and indeed only example of Völkish citizenship legislation in the 1920s. Hitler continued to speak in such terms thereafter, repeating his judgment of American immigration law in 1928. Americans felt the need, he wrote, deploying standard Nazi terminology, to exclude the foreign body of strangers to the blood of the ruling race. That was the felt need that was expressed in their immigration legislation. He made similar declarations in his second book, the unpublished sequel to Mein Kampf that he drafted in 1928. The second book is indeed striking for its depiction of America as a racial model for and future racial rival of Europe. Some German racists in the 1920s portrayed the United States as a country gravely endangered by race mixing, all too likely to go into decline unless the good blood in the Union could hold off the onslaught of a chaos of Völker made up of Negroes, Jews, Southern Europeans, mongrels, yellows, and undefinables from the milk coffee lands. Not so Hitler. By contrast with these fellow racists, The Hitler of the second book was notably sanguine about American prospects. Developments in American immigration law, he held, demonstrated that Americans had seen the light. The capacity of assimilation for the American Union has given out both with regard to the Chinese as well as with regard to the Japanese element. People feel this clearly and know it, and for that reason they would most prefer to exclude these foreign bodies from immigration. In this way, American immigration policies provide confirmation that the previous melting pot approach presupposes humans of a certain similar racial basis and immediately fails as soon as fundamentally different types of humans are involved. That the American Union feels itself to be a Nordic German state and by no means an international Völker porridge is also revealed by the apportionment of immigration quotas among the European Völker. Scandinavians, that is to say Swedes, Norwegians, furthermore Danes, then Englishmen, and finally Germans, have been accorded the largest contingent. Latins and Slavs receive very little, and the Japanese and Chinese are groups that one would prefer to exclude entirely. The happy result of this shift in immigration policies, Hitler concluded, was that America had safeguarded its character as a Nordic state. Europe, he warned, could not hope to compete unless it did the same. This was the same year in which Hitler was proclaiming his admiration for the American conquest of the West, where the Americans had gunned down the millions of redskins to a few 100,000. This, too, he said, offered yet another Nordic example that the Europeans would do well to follow. Assessing some of these writings of the 1920s, historian Detlef Juncker concludes that for Hitler, America was the model of a state organized on principles of Rasse and Raum, on principles of race and the acquisition of territory for a racially defined folk. Gassert, too, holds that Hitler regarded the America of the 1920s with its unapologetically race-based immigration legislation and its epic Aryan colonization of the West as a race state that deserved admiration. The views of the Führer on the subject of the race state, it goes without saying, carried immense weight in Nazi Germany. Hitler's discussion of American immigration law in Mein Kampf, in particular, would be cited whenever Nazi jurists discussed problems of citizenship after the Nazis took the reins in 1933, and it set the tone that remained dominant in Nazi writings on American law throughout the early 30s. America was a country that was, in some ways, weak, and its future as a racist order was perhaps uncertain, but it remained the leading example of a jurisdiction groping its way toward a race law of the kind essential to the creation of a Völkish state, most especially through its sage immigration restrictions. As the National Socialist Monthly put it in November 1933, echoing Mein Kampf and Fritzsche's Handbook of the Jewish Question, the United States of the New World have come to understand the monstrous danger of the great melting pot of races over the course of the last decades and put a check on bastardization through draconian immigration law. To these circles of tribally related Americans, we reach out our hand in friendship. America, as Hitler had written, had taken the tentative first steps. The moment had come for the torch to pass to Nazi Germany, and the hope of a spiritual alliance between Nazi Germany and the white supremacist United States was not to be excluded.